Hello, and welcome to the law firm of Kidwell, Kent & Curran. My name is John Kidwell. Today we're going to be talking about the essential estate planning documents. Now there are three documents that we normally advise everybody have when planning for their estate. The first is the last will and testament or the revocable living trust agreement, depending upon your situation. The second is the advanced medical directive, and the third is the general durable power of attorney. Now each estate should be assessed with individual scrutiny, yet these three documents remain absolutely essential. In this segment, I'm going to concentrate on the advanced medical directive and general durable power of attorney, leaving the discussion in regards to the last will and testament and revocable living trust agreement to another segment. The advanced medical directive is a two-part document. The first part of it is known as the living will. Now a lot of clients, when they come through my doors, are often confused as to the difference between a last will and testament and a living will. They're completely different documents. What the living will says is, should an attending physician determine that providing you life-saving support would do nothing further than to artificially prolong your life, to withhold treatment except for pain medication and the provision of water so that you may die comfortably. In short, if I'm a vegetable, pull the plug. Now this is a moral as well as a legal consideration, no question. But if you would rather that your money go to your loved ones as opposed to the doctors and insurance companies, you want this in place. If you do not want to live indefinitely on a breathing tube and feeding apparatus, you need the living will. And I think just as importantly, you are taking the burden of this decision off of your loved ones because you are saying in advance, my directive is that you pull the plug should the need arise. That's the first part of the advanced medical directive, the living will. The second part of it is known as the medical power of attorney. You put the two together and you get what is known as the advanced medical directive. The medical power of attorney is where you would appoint somebody, an agent, to make all medical decisions on your behalf if you are unable to do so yourself. Now, the law says an attending physician may, that's the operative word, may listen to the spouse or the majority opinion of children over the age of 18 and the spouse. They do not have to. There are two ways that the spouse, for instance, could have the power to make the medical decision on behalf of their incapacitated spouse. The first is to petition the court to become appointed guardian of the person. This is time-consuming, expensive, public, last thing you want to be doing while your loved one is in dire straits. The second way is to have in place and in hand the medical power of attorney. An extremely important document to have. That third document I was talking about is now the general durable power of attorney. The general durable power of attorney is very similar in reasoning as to why you need it in place as the medical power of attorney. Except in the general durable power of attorney, you are appointing somebody to make all business and legal decisions on your behalf if you are unable to do so yourself. Sign contracts, go to settlements, roll over monies from your IRA or 401k. This person can do anything as though they are you. It's general to all business and legal decisions, and durable in that it endures incapacitation. This document can be a document of absolute convenience between husband and wife, for example. I'll say the wife goes out on a business trip, forgot to sign a contract. Honey, can you sign it for me? He can. He has the power of attorney. He can sign, no questions asked. But it transforms into a document of absolute necessity should you become incapacitated. Because if you are adjudicated mentally incompetent, you are now no longer capable of giving somebody the power over you to make these business and legal decisions. The catch-22 of it is, that's exactly when you need it. So you must have this general durable power of attorney in place looking forward to that future possibility. However remote, hopefully. So those are the three essential estate planning documents. The last will and testament, or the revocable living trust agreement, the advanced medical directive, and the general durable power of attorney. Thank you.